We are here now discussing this property to further discuss what the next course of actions will be. Continuing on regarding this ongoing case on this property, me as a code enforcement officer, I exhausted my time and efforts on the property, trying to negotiate with the owner, trying to get contact with the owner, as well as his wife, which no longer lives at the property. I mailed out notices to the vehicles with the license plates. Some of them come back to the property, some of them come back to an address unknown, which I've never received any callback or contact from an outside person regarding the notices that I've sent. And continuing on regarding the citations, I haven't registered the property under non-compliance with the LA County Recorder's Office until we get further action regarding your Planning Commission efforts. Thank you.
You'll see in the staff report under Planning Commission findings where some of the facts that Officer Silva spoke to align with our code sections for what we consider a nuisance, and it will be your determination tonight whether those findings can be made.
Questions for staff?
I just had one question. I was looking through prior to the meeting, the chronology of all the site visits, et cetera. And I know there was, again, I think it was 2015 timeframe when the first rounds were happening.
Yes.
And looks like at that point in time, there was sufficient work done to address the problem. So that was clearly documented. But then I saw it come back up in 2023, I think it was.
23 was the last.
How was that resolved before we got to the current situation over the last year or so?
By 2016, 2023, his wife was with him at the moment, at the time, staying with him. From 2023, I've never seen her at the property at all until now.
But it looked like you were out looking at the property again, possibly, doing site visits in 2020. So there was a series of visits and citations back to 2015 and 16
Yes.
that got resolved.
Yes.
And I saw that documented in the chronology. But I didn't see what happened in 2023. There was another round that started, but it just sort of stopped. So I was just wondering if that was resolved because there were efforts made.
Yeah, I
to clean up the
believe
property.
it continued on regarding the brush clearance. Fire department has gone out there twice. As I didn't get photos of the roof, but there is tree branches and tree limbs on top of the roof. So fire has been out there a couple of times to notate that.
Recently.
Yeah, recently. And then from that point on, a couple of neighbors, one of the neighbors that lived across the street had an altercation with Mr. Glenn Springer. He actually threw rocks at her property, trying to hit her. She was afraid of him, so she didn't file a police report. She didn't call the police department. So pretty much most of the neighbors are afraid of him. I advise them if they can go ahead and send a public comment. I believe there was one that was sent in. This is regarding the issues that he's been observing for numerous years. But he's been compliant in the beginning, like you said, before 2023. After 2023, he's been just not complying, not cooperating with myself or any other staff member of the city.
Okay. Thank you.
So if the fire department has gone out there and cited issues, why are we involved? Why isn't this going through whatever the normal channel is that fire would conduct?
So I think there was a flow chart included in the staff report, which is one of Alex's many creations. But on that chart on the very left, there are two paths under the nuisance abatement. And on the left, I believe you'll see, I won't make you guys zoom in too much, I'll just tell you. But you can keep issuing citations and doing things like what the fire department has already done and exhausted, but it's ultimately just racking up fines and citations. It's not actually abating the problem unless the property owner complies with doing so. So this is an alternative option where abatement is more forcibly done by us conducting it when the property owner does not comply. So the intent behind a citation is that then the property owner willingly abates the nuisance conditions themselves and remedies those problems on their own. However, this is a rare situation. Most of the time, 99% of the time, the property owner is going to want to fix it themselves and be in compliance with the code. This is just a situation where we've time and time again tried to issue a citation, tried to remedy it in a more amenable manner, and no action has been done.
Okay, so I guess specifically to the citations that the fire department have produced, right? Are you saying that the only thing that the fire department has the purview to do is to fine? And if the fines just continue to aggregate, nothing else happens? There's no other enforcement other than issuing more fines?
In terms of what I'm familiar with on the options under nuisance abatement, that's where their authority ends. I'm not familiar with any other situations where they take it further beyond city action.
If I may say something, just typically if there's non-compliance with fire, they would usually bring it over to code enforcement, and I would start a new process for notice of violation 1, 2, 3, and then continue on with my citation process. They don't issue citations. They'll issue the notices of violation for what they see on the property per fire code violations, but they don't issue citations. That would be addressed to me after, if they resolve however how many notices they would send out to the property or business owner. They would basically hand it over to me so I can continue the enforcement process.
And so I'm just trying to understand how the fire department goes out and checks all these houses and there's no enforcement arm except holding a public meeting to determine whether or not. So you're saying that the only enforcement avenue to get change at this house, regardless of how many times the fire department says that it's bad, is to have enforcement issue citations, and there's no teeth to those citations?
No, it's just like any other citation where it's essentially a fine. Until there's compliance, there's a window of time for them to remedy those issues, and if it's not done timely, then you can issue another citation. But that's essentially where that ends, and when the city starts to consider other options, which is what that flow chart was trying to show. But I think to make it more clean cut for you, yes, that's where that ends. There isn't another prong to the teeth on a citation.
So example, like if I had a regular property, he had code violations for municipal or building code, and it's structural or any type of permits, then that would give me the enforcement to record the property under Los Angeles County Recorder's Office. And that will be taxed every year when he files his taxes. In this sense, I have not done so because this is property maintenance violation, which is vegetation. Not so much where I should have recorded the property so he could get penalized, because this is where we're at right now, because it's just basically where he can try to do to accommodate the cleanup, and he hasn't done so. So that's why we're here now, is to accommodate what we can do to continue the enforcement on the property.
Okay, so I think what I heard you say is, had you recorded this with the county already, which you don't need our help to do. You can do that on your own. Then all of these fines would be recouped through the tax roll?
If there was other violations like building code violations, structural additions or re-roofs, then I would record it because there's building code violations. This is basically property maintenance, which is vegetation. It's not substantial, not that much of a life-threatening, life safety issue. Even though in a sense where it is, because fire went out there, they notated the overgrown vegetation, the debris, the tree limbs on top of the roof. So there is a violation, but it's property maintenance.
Okay, so I guess I'm just having a hard time. I want just like a yes or no answer. Are you allowed to record this property with the LA County for the violations that we've seen so far?
Not under this section, not under this property maintenance issues.
Okay. So we can fine people
We can find people,
and never collect it.
basically, yes.
I mean, that feels like a bigger problem than a planning commission problem, if I'm being perfectly candid, but,
So the next course of action, which I have not done so because I'm waiting for direction, is misdemeanor. This is administrative. I can go misdemeanor fines, which would definitely add up on the property and against the property owner. Right now, this is all administrative. Administrative is on the property for the code violations. I haven't got into misdemeanor where prosecution take it to actual court. I can go that route if there's nothing else we can do at this point. But I haven't done that because, like I said, it's property maintenance violation, which is an easy fix, and I've been trying to accommodate with him, but I'm not getting anywhere with him.
yeah, no, that makes sense. And that definitely came through in your report. I was trying to get clarification on the process because it seems like if I get a ticket while I'm driving and then I don't pay it, they take my car the next time they pull me over, right? And so I'm trying to understand how we have a policy that doesn't have any way to enforce it.
So from this point on, depending on management and planning commission, for further enforcement, because administrative is just in-house with the city staff, if from this point on, if there are code violations and it's an ongoing issue like when I had started back in 2016, I should have done misdemeanor at this time. And all that money would have been allocated to the court. I mean, if it was misdemeanor violations and citation.
I'm a little,
Because
can you
municipal-
clarify the misdemeanor piece to me?
Misdemeanor is,
Like,
is
what would be
infraction,
the
like infraction for the code. Administrative is, so, I'm tongue-tied right now. So administrative is, it's not through court. Misdemeanor is through court, going through the
Right.
judge. Yeah.
I'm just trying to determine, because I'd seen the code piece on where we codify what a public site nuisance is, and that's where the administrative remedy comes from. But I
Right.
didn't know where it's codified, like what type of a misdemeanor it is.
Yeah, it's not on there, that's why. It's
Okay.
just, it's administrative.
Okay.
So there is a remedy outside of this nuisance process? Is that what he's saying?
To be honest with you, I'm not familiar with what that other process looks like, so I can't speak to it. I am now coming to the understanding that apparently there are misdemeanor charges for this.
Sorry to interrupt, wouldn't that mean, though, we're still not resolving the issue, right? So in the same instance where we're issuing fines that are going unpaid and the fines aren't being paid, but in addition, the property isn't being abated, it's not being remedied. If you went to a misdemeanor process, because we'd have to get clarification, but that, to me, a misdemeanor would be additional fines and or jail time, typically, then we still have a property that's not being abated. So, and this remedy, while I understand the concern from the chair, this remedy that we're talking about tonight is codified in the municipal code as a
Correct.
specific remedy that the planning commission can take to deal with these types of issues. Correct?
Correct.
So can I get some clarification on if we do go that route and we issue it and this homeowner still does not, and so then we would take care of it and then bill them for it. That's kind of the idea, right? What happens when those people get there and the person decides he's not going to let them, like get into the property and all of that combativeness? I mean,
So it's a
That's-
legal order.
okay, so then
So then
it would be dealt with in a
PD would-
legal
It
matter.
would be,
Okay,
yes.
Could be arrested if he's
Right, I think
involved.
Okay.
they actually have a warrant to be on the
yeah, they
property.
have
I
a
see,
warrant to be on
okay.
the property as part of the process.
yikes, okay.
And I guess to clarify that distinction, there is a point in this process where then the city has authorized the police power, and that's when I would get a court warrant to handle it under police power.
Okay. But to your point, though, we get to a point where it gets cleared, right? So, yeah.
Yeah, I mean, I think the question is, we have, or the point is, we have an avenue to resolve the underlying issue, which is the property and the condition it's in. But,
Other questions for staff?
So this is the fastest way to get the job cleaned, or the, basically. Otherwise, it's just fines and.
But again, so tonight, we're determining that there is a public nuisance, I think, right? And then if we declare that, then there's a public hearing, and the property owner could come to the next meeting, and we'd have a public hearing. He could address the commission, and he would have, obviously, the opportunity at any point in time to abate the problem. And then you would, if that didn't happen and we were to move forward with the potential for the city to step in with a warrant, he would, I believe he said he'd still have additional time, correct, to address the issue, maybe 30 days, and if that doesn't happen, or is that, did I have that right? But basically, obviously, the homeowner property owner can step in at any point in time and abate the property, right? Even up into the public hearing, right?
I did post a notice, so he is aware of the hearing today, so I didn't get no call back.
But we're gonna have
But you're right. So after tonight, this is just deciding that there's enough facts that meet our code for what we consider a public nuisance. Then, at that point, we give him notice of the public hearing that we've decided to hold, and up until then, if he decides to abate, he can. Then, at the public hearing, after you decide whether or not to give further direction, then that's when the 30 days comes in, that they can still abate themselves or appeal the planning commission decision. Then if they fail to do so is when there would be a city council closed session, which would authorize the city attorney to essentially take legal action on behalf of the city, going to the courts to get that warrant and administrative inspection order. So you're correct, there are plenty of opportunity for them to abate themselves, should they so choose.
And on here, it says adopt ordinance identifying nuisances. So we have to actually codify that this is a nuisance?
No, it would be a resolution. I'm not sure where it says that. That might have been a typo.
Right under nuisance abatement at the far left, I think that's the road we're going down, directly below it.
Sorry, my laptop is deciding not to work, but is that on the far left bracket?
Far left bracket. The very top one is nuisance abatement.
So we've already adopted an ordinance which identifies what we consider nuisance conditions, and that's in 8.16010.
Okay, so where are we on this chart then?
So this would be we would be seeking an administrative abatement. So I guess that would be the third box down. Or let's see, 1, 2, 3.
And what's the difference between an emergency summary abatement versus an administrative abatement?
To be honest with you, I did not put this together, nor have I ever heard it be referred to as an emergency abatement. So I'm sorry that I can't speak to that more.
Okay. Well, I'm sure there'll be more questions, but it sounds like we don't have any just this second, so maybe we'll go ahead and take public comment and then deliberate. Does that work? All right. Thank you. Stay close. We may need you. All right. At this time, Anyone may come before the Planning Commission and speak to this specific agendized item. Please keep your comments to no more than 3 minutes and identify where you live for the record.
Chair, there are no comment cards received, and there was one public comment received in advance of this meeting, which was forwarded to the Planning Commission for their consideration.
I can confirm I received it. Thank you. At this time, we'll go ahead and close public comment and bring it back for deliberation. Who wants to start?
I don't know. It looks like this has been ongoing with fines and everything for the last couple of years. Nothing's getting done. It would be nice to see it cleaned up. I think that I have enough evidence. I drove by, saw the pictures, to have a public hearing about it.
I'd concur. I think code enforcement officers demonstrated enough evidence, and there's seemingly a lengthy record here, not just in the past, but in the current situation for the past year or two, to evidence that we've got a site nuisance.
I agree. I mean, it's kind of sad that it's gotten to this point, I guess, and utilizing a lot of time of folks that could be doing better things, right? And I mean, I hate to get into other people's properties to take care of these things and all that, and that but it is, we're a community, and one affects the rest of us. So I would concur that. Be okay with it.
Yeah, I think the concern that you voiced is what I'm having such a hard time with here, is that this is somebody's private property.
Yeah.
And if they want to have overgrown plants that I may not like, that's their right, as long as it's not infringing on public safety, which was why I was so digging into the fire side of it. There was an old blue car that wasn't operational that was parked at the corner of Grandview and Auburn for years and years and years and years and years until they finally just sold that property. And I don't see a difference between that and the vehicles that are there. So I'm trying to really focus in on what is actionable here and what isn't, and what is a matter of opinion versus what's actual life safety, right? Across the street from there is a hill of low ivy. We all know that the rats love to live in the ivy. Is that a public safety issue, right? Should we be asking them to abate that? And so I'm really challenged with where it is that we draw the line between somebody's private property and public safety. And so I guess maybe I talked myself into another question. Who determines what the abatement looks like?
I'm actually not sure when along the process that gets specified. I believe it's something that the police department works in conjunction with whatever the court order was, but I'm not positive about that, and I'd have to speak with Alex to get back to you. And that would be, I believe he's going to be at the next meeting, and that would be a concern that could get addressed when Planning Commission gave authorization at the next public hearing.
I'm very sensitive to property rights and homeowners' property rights. I'm just, to your point, can I convince myself that there's enough evidence here? And certainly there's a matter of opinion, I think, that's going to be applied to this, but I'm relying on Code Enforcement Officer Silva to relay what's happened. But I'm just reading the documentation here and the different Sierra Madre municipal codes under 8.16.01.010D, H, I that's laid out in the report. And just based on, and I also visited the property, based on the pictures that I've seen that Officer Silva's documented, as well as pictures that shown here, as well as looking at the site from the street, I'm fairly comfortable that all these, if what is our yardstick, right? So municipal code has certain subparagraphs that outline what a nuisance is in this case, a site nuisance. Premises maintained so as to constitute a fire hazard by reason of woods, rank overgrowth, or accumulation of debris. Seems like there's substantial debris and overgrowth on the property. Likely to harbor rats, vermin, or other nuisances causing detriment to neighboring properties or property values. I think that's a definite yes. So as I go down the report, again, it is a matter of an opinion, I guess. But if I go down these sub paragraphs within the municipal code, it seems to me that the documentation that the code enforcement officers put forth to us and the pictures and just simply looking at the property, it seems like the evidence is there, at least from my vantage point. If that's our yardstick.
Yeah,
So-
yes.
But I agree. I'm very sensitive to property owners' rights by all means. I think the question is when we get to a situation like this after numerous attempts to correct an issue and it hasn't been corrected, we're here, unfortunately.
And maybe at the hearing, there could be a detailed description of what actual things they're going to be working. I mean, because we're just.
Well, yeah, I guess that's my question is, at the hearing, are we going to go through each one of these and determine which ones we would move forward with?
Sorry, can you repeat your question?
Sure, so under the Planning Commission findings, at the very end of the report, right before the flow chart, it has the staff recommendation of all the site nuisance codes. And so would we be going through those one by one at the public hearing and determining which of these that we would want to put forth and have applied?
You certainly can, and that right after the flow chart and all the evidence, I believe, is attached to the resolution that we're proposing. And it does reference those code sections. We're actually calling Alex right now because he is available to speak to some of your questions. Is he on, Josh?
I believe he is on.
Mr. City Attorney, can you hear
I'm
us?
on the call. Yes, I can.
Fantastic, thank you for joining us.
I hear you have some questions. Happy to answer them.
Thank you. I think one of the questions we had is who decides the level of abatement that gets performed?
The abatement is going to be determined at the staff level based on what items have been identified as site nuisances. So for example, right now all we're doing is setting up a public hearing if you choose to adopt the resolution. Once that resolution is adopted, you're going to have a public hearing, and at that public hearing, you'll consider whether to adopt a resolution ordering abatement. And in that resolution ordering abatement, staff will list out for you all the public nuisances that we feel need to be abated, and you will choose which of those need to be abated, and staff will determine the appropriate method for abatement.
Okay, that is definitely helpful. That's a much more surgical response than I think some of us were worried about. Me, I was worried about it. Did somebody else have another question that they'd asked earlier? I guess one of the questions that came up is our understanding is that we can fine and fine and fine when the fire department does not, or when the fire department finds something out of compliance for brush abatement and the sort, but all those fines do is continue to grow, and there's no enforcement action associated with those fines. Is that correct?
Correct. Administrative citation only works if the person that's receiving the citation is going to change course as a result of the financial penalty. If that doesn't work, there are alternative options. This is one of them, that we go in and we do the abatement ourselves as the city and charge the property owner for the cost of that abatement.
One of the things that was mentioned was I guess, a police action version of this where it could be a misdemeanor to not do the abatement. Are you familiar with this?
Yes. almost every violation of our municipal code is we have the discretion to prosecute as a misdemeanor, but to date, Sierra Madre does not prosecute violations of its municipal code as misdemeanors. Although I've done it in other cities, we've never done it in Sierra Madre.
When it becomes a misdemeanor action like that, is that something that you see better success with than the administrative side?
A misdemeanor can result in one of two things. Either it's going to be a fine up to $1,000, or it can be up to 6 months in jail. And I think it's highly unlikely that a court is going to seek a jail term for a site nuisance. So I don't think that's the best remedy here.
Okay, any other questions? All right, thank you.
Welcome.
So it sounds like there's mostly agreement that there's sufficient evidence to move forward with a public hearing to determine which of these to possibly move forward with. So I guess we'll look for a motion for that.
I'll make a motion to approve resolution number 2602, declaring a public hearing to investigate a potential public nuisance.
I'll second.
All those in favor?
Aye.
Motion carries unanimously. All right. Next up is our California Legislative Update Part 1. I love when it's Part 1.
You know it's going to be good. Okay, I have some slides for you all. And we're focusing primarily on ADU law tonight. So here's an outline of the bills that we'll be covering tonight. We spoke at our last, or I guess 2 meetings ago, about AB 3074 briefly in terms of the Zone 0 fire safety defensible space requirement. The next bills are all related to ADUs and JADUs. And then lastly, slight amendment to SB 9 historic resource exceptions for ministerial review. Okay, so this was the one that I was talking about in terms of a Zone 0 zone. And this did become law already, but as we spoke about previously and is still the case, it's yet to become enforceable because the State Board of Forestry and Fire Protection, in consultation with the state fire marshals, still have to officially adopt and approve implementation requirements. But essentially what we're expecting is that they'll come up with more specifics for what the 5-foot ember-resistant zone around structures entails. And until then, we can still choose to enforce or encourage such practices. The purpose is just to reduce structure ignitions from wind-driven embers in wildfire-prone areas. And I have a visual of where that Zone 0. So it's that 5 feet right around a structure, and it's essentially removing any combustible material, such as vegetation, and using fire-resistant materials. And one last note on this section. So this applies in the fire hazard severity zones. Okay, AB 130. So for background and getting into what the 2018 ordinance exception was, so cities must approve ADUs ministerially, and there are certain protected types of ADUs where it's limited what development or design standards can be imposed. And there was a carve-out where if a city had adopted an ADU ordinance before July 1st, 2018, allowing ADUs in multifamily buildings, it could still objectively or apply objective standards. But this has tightened that up and it does two things. So AB 130 removes that 2018 ordinance exception. So cities that had a prior ordinance no longer get some kind of special authority to impose objective standards, and they must treat them like the other fully protected ADUs under state law. And so that's essentially further restricting local standards. It also specifies that within reasonable restrictions and covenants, restrictions, and conditions that cannot include any fees or other financial requirements. The intent there is just to not include anything that would make it more expensive to have an ADU. There's also a 6-year building standard moratorium, which I'm going to go through the exceptions to that on another slide, but that ends on July 1st, 2031, and that's a moratorium for all state and local building standards that affect residential units. There's also a CEQA exemption for infill housing, and we'll also go through what qualifies for that CEQA exemption. And then lastly, there's a requirement now for homeless shelter inspections and recording requirements regardless of whether a complaint has been filed.
Do you want questions as you go?
Sure, I'll pause now if there have been any
Yeah,
questions.
I had some questions about that. What building standards are subject to the moratorium?
So everything but...
Oh, I didn't know you had a slide on it.
Yeah.
I'm sorry.
No, that's okay. So everything but things that are substantially equivalent to building standards that had already been in place. So they're the state building standards, and if we already had an ordinance that was a change to that, then we can, on the triennial basis, essentially like update that every time the building code is updated, the state building code. The other exception is for building code provisions that are deemed necessary as an emergency standard to protect health and safety. And that's something that would be determined by the California Building Standards Code, or no, California Building Standards Commission, whether it was deemed necessary. And then related to home hardening for wildfire mitigation. And then there's also a handful of really narrow exceptions. And so I gave you an example where if it's necessary to implement a local code amendment aligned with the general plan and it permits mixed fuel residential construction while also incentivizing all electric construction as part of an adopted greenhouse gas reduction strategy, that's an exception to the building code moratorium. Does that answer your question?
Yeah, so the home hardening, so the zero zone, which wasn't in effect or enforceable yet, when it becomes enforceable, that is one of the moratorium exceptions, and they will have to be subject to the zero zone for ADUs.
Correct.
That's a very interesting one when you consider the fact that the setbacks are different for ADUs, and they could be right up against a wood fence, which they couldn't have in the zero zone. So now we're getting our setbacks back.
I didn't notice that, but yeah, essentially. So AB 130 also is a CEQA exemption where instead of having to do the usual environmental assessment, there's a phase 1 environmental site assessment. And if that phase 1 environmental site assessment identifies a recognized environmental condition, then there are related mitigation measures that will be required. But other environmental study is not required, and they don't have to go through the usual CEQA process if it qualifies under all of these, which include that the project type is a housing development project as defined under the government code, which includes single-family residences, multifamily communities, mixed-use developments, transitional housing, et cetera, and that the site area is under 20 acres in size, that the location, the project site is in the incorporated municipality and is not located in a specific area of a coastal zone or environmentally impacted or sensitive area. The project must be developed with urban uses or substantially surrounded by urban uses. And urban uses means any current or previous residential or commercial development, public institution, or public park that is surrounded by other urban uses, parking lot or structure, transit or transportation, passenger facility, retail use, or any combination of those uses. And the project must be consistent with the local general plan and zoning standards and any applicable local coastal program. Or I guess there's two more, but minimum density, it must be at least 50% of the jurisdiction's minimum density. And then the project must not require the demolition of a historic structure. And so the difference between this and prior exemptions is that AB 130 does not require affordable housing, although local government inclusionary standards can still apply, and it requires payment of, nor does it require payment of prevailing wages.
So is the hillside zone considered a sensitive, is that what you called it? Sensitive area?
Do you know, Josh?
Whether it's sensitive or not, I'm not entirely sure. I'd have to look at the definitions for what sensitive mean, but it is considered an urban infill project or an urban infill site. All developable areas within the city of Sierra Madre are considered urban infill.
I believe there is a map out there of what are sensitive areas or not, but I'm not familiar with whether the hillside is. Are there any other questions about the CEQA exemption?
I could also clarify with regard to the high fire hazard severity zone.
That's what I was just about to ask, yeah.
Yes, because the city of Sierra Madre has adopted a building code standard that mitigates for building and construction within the high fire hazard severity zone, the exceptions that prohibit construction in there do not apply.
Okay.
It's if you recall the SB 9 law, where SB 9 in some cases would not apply within high fire hazard severity zones. The exception to that rule is similar, as if this local agency had mitigations in their building standards code adopted and applicable. And in Sierra Madre's case, it does.
Okay, thank you.
So still under AB 130 is homeless shelter inspections and reporting. So there must be an annual shelter inspection conducted regardless of whether there were any complaints received and regardless of the shelter's funding sources. And this is in addition to the requirement for an inspection upon a complaint. There's also now the requirement to submit an annual report to HCD regardless of any complaints were received, and that report would include if there were complaints made, how many were received that year. And the HCD department is required to withhold state funding from a city or county that fails to comply with that reporting requirement.
Was this responsive to the relocations in San Francisco?
That's likely. It wasn't mentioned in the legislative report, but it's possible, yeah. Okay, the next bill, SB 543. So this applies to ADUs and JADUs. So the maximum size for ADUs and JADUs was clarified by providing that all the sizes discussed are net square footage, and the phrase interior livable space was also added. And interior livable space is a space in a dwelling intended for human habitation, including living, sleeping, eating, cooking, or sanitation. And this differs from some other pieces of code that refer just to habitable space, so this became a different definition for what that square footage entails. And SB 543 also now requires that local agencies adhere to the post-entitlement shot clocks in processing ADUs and JADUs. And so now the requirement is that once an application is received, there must be a determination within 15 business days for whether it's complete or not. And then after that, there is a process for that applicant to appeal the determination of incompleteness, and a 60-day window for a final written determination upon an appeal. And just to clarify what the difference here is, there's a default state law for 30 days for permits under the Permit Streamlining Act. So this 15 days is an acceleration.
And this will change, livable space will be kind of a separate definition that now we have to look at as well to get to the 500. Like, is closet space considered livable space? Because it's not listed as one of those four.
Those are questions I also have.
Okay.
So the other thing that this second, or I guess that's the third, but second big bullet point does is that now an applicant would have to exhaust these administrative remedies before they could sue over a determination on that. So review by HCD is now required for all JADU ordinances. Previously, this was only required for ADU ordinances. And in terms of fee limitations previously imposed on ADUs, now that also applies to JADUs. Additionally, ADUs and JADUs that are less than or equal to 500 square feet of interior livable space are exempt from the calculation for purposes of school fees. And the statutory ADU provisions were modified to codify what was already HCD guidance regarding the number of ADUs that must be permitted per lot. So the amendments now specify that we must allow for one attached, one detached ADU plus one JADU on a single family lot, internal and external ADUs on multifamily lots. And then there's also been a codification that fire sprinklers may not be required for JADUs if they're not required for the primary dwelling. Any questions on this piece?
Yeah, so I guess I forgot that there's an attached ADU, because I thought when it was attached that it became a JADU. But there's, what's the difference between a JADU and an attached ADU?
A JADU may share, or it may have circulation within and to the attached single-family residence. And if it is like that, it does not require its own separate bathroom or cleaning facility. So it does require its own kitchen or cooking facility, bedroom space, livable space of no more than 500 square feet. And if it doesn't have a bathroom in its own space, it can open its circulation up to the attached single-family home to access that bathroom.
And it still has to have the door to the exterior?
It still requires exterior access.
Okay.
Yes.
So can I just sound check? You said a single family can have a detached ADU, a detached ADU, and a JADU. All three, is that correct?
That's my understanding.
So if I'm going to understand that in planner's terms, that's a potential triplex with a detached unit on a single-family property.
Right.
Okay.
And if they're under a certain square footage, we have no purview over them.
That is correct. So for ADUs, the exemption maximum amount would be 800 square feet, and now that would be measured of interior livable space.
Mm-hmm.
So I could attach a two-car garage to a JADU, and because that two-car garage is not a livable space, the JADU could be 1,000 square feet.
If the garage we're talking about is attached to a single-family home, then yes. But if the garage is detached, then it's not part of the single-family home and would
Right,
not.
then it wouldn't.
It would not
Part of the JADU.
qualify as a JADU. It can qualify as an ADU, but not as a junior ADU.
Okay, so AB 1154 requires that JADUs can no longer be used as short-term rentals, and if they are rented, that it must be for a term longer than 30 days. And there's also a specification that if a JADU has shared sanitation facilities with the primary structure, then owner occupancy will be required. And conversely, if the JADU does not have shared sanitation facilities, owner occupancy will not be required. Alex and I were talking about this, and even though it can be a deed restriction for owner occupancy, it's not clear how owner occupancy is enforced.
That was literally what I was about to ask.
The intent here is to encourage more JADU creation and long-term housing supply while addressing some of the neighborhood impacts of short-term rentals. Are there any questions on this piece? Okay. AB 462. So certificates of occupancy normally cannot be issued to ADUs before a certificate of occupancy is issued for the primary dwelling. And you may recall, because of the Eaton fires, but there was a governor's order that allowed for an ADU to get their certificate of occupancy for the primary dwelling when that property was affected by an emergency that was the basis for that emergency proclamation. And this is essentially codifying that to be used in the future and more broadly.
Did it impose any time limits as to how long the primary residence had to be built?
I'd have to double check that. I believe there was a time window. I don't think it's like indefinitely, obviously, but I think it's for a while that like state of emergency exists. And then I think there's a window of time for rebuilding. The purpose is obviously that we want people housed and to make that a cheaper, easier option. And I can't remember the exact time frame, but.
And are you allowed to sell the house before you've made the primary, before you've gotten a certificate of occupancy for the primary residence?
That's a good question, and I will look into that.
Okay, thanks.
Okay, I'm referring to it as SB 9, but I just want to clarify that that's because that's the number of the bill this year, and it's not SB 9 in terms of lot splits and what we're familiar with. So this piece, so city ADU ordinances adopted pursuant to Government Code Section 66314 are going to be considered null and void if they are not timely submitted to HCD. And this includes also a piece for timely response to HCD findings, where if you don't respond within 30 days, then that ordinance also becomes null and void, and we can only apply state ADU law when permitting ADUs. What's not clear is whether there's an option for resubmission. So this may be insinuating that you only have one shot with that ordinance and timely submission. Okay, this is referring to SB 9, the one that you know. So here, as we're probably familiar, SB 9 has required ministerial approval for certain 2-unit housing projects and urban lot splits without the discretionary hearings unless certain exclusions apply. And there was an exception to ministerial approval for properties with recognized historical significance. Some jurisdictions took this and ran with it and applied that exception broadly to all of the parcels in large historic districts, and that was something that happened with the city of Pasadena, and HCD prevented them from doing so, and this is essentially legislation backing up what HCD tried to impose there and reinforcing it. And so this is attempting to balance housing production goals with preservation of historic resources. And now when processing an SB 9 application for a 2-unit development or urban lot split, we'll have to determine whether any of these AB 1061 historic resource exclusions apply that would make the project ineligible for ministerial approval. So I outlined when it's not subject to ministerial approval, but I think the last bullet point is actually, it's the converse of all that, and I think it makes it a little bit more clear to understand. So you can still ministerially approve it in a historic district unless the property itself is registered as a landmark property or local landmark site, or there's a contributing historic structure there. Any questions on this? Well, that was relatively painless. That was all we have for tonight, and there will be a part 2, so stay tuned.
Great, thank you. At this time, we'll take public comment. Well, this was just a presentation, right? So we don't need to do public comment? Okay, great. That moves us on to reports from Planning Commission. Any commissioners have anything to report?
No report.
All right. Reports from staff.
Chair Dennison, so at the next city council's meeting, like Mayor Lowe mentioned, the city council is going to hear from the applicant appealing the planning commission's decision on the design review for the Meadows project. And all the information will be uploaded onto the website. We do have a transparency portal for the Meadows, which is www.sierramadreca.gov/meadows. So all the material will be on there. And for our next planning commission meeting, we are going to review the municipal code text amendment for the ADU ordinance and some other cleanup ordinance. And if the time permits, we have to allow that public hearing noticing. If the time permits, then we will schedule the public comment, public notice for the abatement. That concludes my report.
Great, thank you. Anything else before we adjourn?
I just want to, I was taking a walk today and there's, I'm usually up on Sunnyside, and I was thinking about the Meadows project, and I went onto the city website, and I would just encourage the commissioners, if you haven't looked at the amount of transparency that staff have put up, it's very robust. Lots of legacy documentation, there's new updates on timelines, what's happening, the new soil sample reports, et cetera, et cetera, et cetera. There's a lot of great information there, so super helpful.
Great. Thank you, everybody. We're adjourned.
Thank you.